taking argument of further count of further affidavit and response of the defendant. When response of the claimant, sorry, when the matter came up, when the matter came up on 10th of February 2026 as scheduled, SNH Andrew SAN appearing for the claimant informed the court that parties are making effort to settle out of court. However, NOA Esquire counsel for the defendants informed the court that they are not aware of any meeting to settle out of court. Also pointing out that the claimant has filed another suit at Federal High Court, which has negated the issue of settlement out of court. The case was then adjourned to 26th day of March 2026 to enable the parties continue effort to see if they can settle the matter out of court. On 26th day of March 2026, when the suit came up before the court, SNH Andrew SAN informed the court that progress on settlement is on and what is delaying the filing of term of settlement was the absence of vice chancellor that traveled out of Calabar. The landed senior counsel appearing for the defendant Imba Ikweni SAN promptly expressed surprise as counsel said he is not aware of any meeting to settle the matter out of court. After a heated argument, the court also asked the defendant, the first defendant who appeared virtually on that day before the court concerning the issue of settlement, and he stated that he was called for a meeting at the office of the vice chancellor, but the meeting was not for settlement. In the circumstances and in view of the fact that all the processes of the parties are before the court to conclude the hearing of the matter, the court resolved to proceed with the hearing. The claimant argued his motion for stay of proceedings. The defender replied, and the parties also proceeded to argue the further counter affidavit, and the reply to that by the claimant. The matter was then adjourned to today for judgment. I shall start with the resolution of the motion on notice for stay of execution. The claimant, by the motion of notice filed on the 9th day of March 2026, supported by an affidavit of 6 paragraphs, is praying the court to stay proceeding in this matter pending the determination of the dispute. Pending the determination of this dispute pending before the Federal High Court in FSCC/CS/23/2026 between Professor Asuko Ekanem and others and Corporate Affairs Commission. And another, the application was argued by counsel for the claimant. The defendant's counter affidavit was filed on the 23rd day of March 2026. It was relied by counsel for the defendants, and also the written address as his argument. I have digested the argument of counsel for both sides. I have considered the affidavit in support and the counter affidavit in opposition, the written addresses of counsel for both sides. Let me say that in law, the usual cases of application for stay of proceeding arise where a party who has appealed against an interlocutory ruling seeks to stay proceeding in the matter before the court pending the outcome of the appeal in the interlocutory decision. See the case of Akilu versus Payomi number 2. See also the case of Ejo BC versus Onyewu. Versus Onyewu. However, this does not rule out that Granting of stay is only in cases where there is pending where there is a pending appeal where there is a pending appeal in interlocutory appeal. An application for stay of proceeding is calling for grant of equitable remedy, which is which is dependent on entirety on the discretion of the court, the discretion of which must be exercised judicially and judiciously, and not as a matter of course, but based on facts and circumstances of each case. That's why there are guidelines for consideration of application for stay of proceeding. On the important factor the court takes into consideration in determining an application for stay of proceeding is pending appeal. There should be a pending appeal before an application for inter for stay proceeding must be valid. See the case of Nika Fishing and Co versus Latina Corporation. However, as pointed out earlier, it is not in all cases that appeal must be pending before an application for stay can be granted or made to the court. An application for stay is, in this matter, though not predicated on an appeal, it can still be considered and may be granted if it satisfies the conditions for its grants. The application for stay in this case is based on pendency of another suit filed at Federal High Court during the pendency of present case. In the circumstances, other factors must be taken into consideration in deciding the factors. Some factors must be taken into consideration to determine whether to grant the stay or not. Since the present application for stay is predicated on pending suit, the court will consider the principles of hardship. A court of law will most be reluctant to grant an application for stay if it will cause greater hardship than if the application is refused. The question of hardship is a matter of fact which can be deduced from the competing affidavit evidence. The moment the court comes to the conclusion that the grant of application will do more harm than good, it will refuse it. See the case of Kibo Nigeria Limited by Holman Brothers Limited. See also Arojoye versus UBA. In determining the application for stay of proceeding, the court will also consider the competent rights of both the applicant and the respondent to justice. In other words, the court will take into consideration the equity and justice of the application. See Nika Fishing and Company versus Levina Corporation Supra. In this case, the grant of an order of stay of proceeding will definitely result in an undue delay in determining the pending suit. More particularly when all the processes are already before the court for the proper determination of the substantive of the originating summons. And the case, in the case, it is in this case the principle of law that a matter ripe for conclusion should not be stayed indefinitely, prohibit the court from allowing such an indefinite postponement. Since this matter is ripe for conclusion and judgment, it will be unjust and contrary to the principles of equity and natural justice to delay it indefinitely by granting a stay pending the determination of a later action. Therefore, the claimant cannot competently seek to stay proceeding in this suit when the matter before the court is ripe for judgment. Therefore, to stay proceeding, it will occasion hardship and endanger the right of the parties to timely determination of the dispute before this court. If this court is to accede to the request of the claimant by granting stay of proceeding, it will validate on the equitable principle of that state that justice delayed is justice denied. A litigant may not, by deliberate delay or by commencing fresh proceeding after the suit is ripe for decision, prostrate the timely conclusion of the case, and thereby deny the opposing party of the right to have the matter definitely determined to finality. It is to be noted that the claimant was granted adjournment to enable it verify the authenticity and the veracity of the letter from Corporate Affairs Commission, Exhibit D19. Instead of informing the court of the outcome of the verification, counsel decided to file application for stay of proceeding to frustrate the delay and conclusion of this suit for it to pursue another remedy in another court. The claimant's application for stay of proceeding pending a letter suit is an attempt to tactically further delay and timely determination of this suit. This antics is not acceptable to this court. This court must also reject the attempt to rely and invoke furtherance of justice to bypass established procedural bars and to permit a party to relitigate matters that would have been resolved in a pending action. It is a principle of law well established that a party is stopped from litigating a matter which had been a subject of litigation between the same parties, even where the party does not inadvertently or negligently fail to put forward every subject of his case. See the case of Peter Paf, Dizembe versus Oram, Obishe, and another. In this case, the apex court stressed the doctrine of res judicata, preventing a party from splitting its claim and using a subsequent proceeding to frustrate the determination of the present case. Moreover, the law is settled that technicalities must not be used to perpetrate injustice, and the present application seeks precisely such a manipulation of process. The matter is ripe for judgment, allowing a state will reward delay and contravene the principle that court must not be used as a tool for tactical obstruction. If request of for stay is granted, it will be granting approval for counsel to convert taxes into a license to delay final judgment and will undermine the court's duty to deliver timely justice. I consider this move by claimants as a belated technical contest to display substantial resolution of the court. I do not know what prevents the claimants from contesting the validity of Exhibit D6 in this case, since it is an ancillary issue to the substantive suit before the court. The court have moved away from technicalities and emphasized the need to patronize substantive justice over technical maneuvering that would create unjustified delay. There is also the legal maxim that in case of two pending suits, the first in time is given priority, i.e., that the prior in time is stronger in right. The proceeding before this court, which was instituted, argued, and adjourned for judgment in the earlier exercise of judicial process, and therefore prima facie command precedence over any suit subsequently instituted in any other forum. The the claimant who also instituted this suit has not shown that there was any special circumstance warranting the exercise of the court decision in its favor in granting stay of proceeding. In the circumstances, the application lacked merit and is hereby dismissed. For the above reason, and in order to prevent claimant from frustrating the determination of from the determination by successive or collateral proceeding of the proper course is to refuse the said application for state and proceed to deliver judgment. And I hereby refuse it and proceed to deliver judgment in this matter. I now turn to preliminary objections of the defendant to the competency of this suit. The argument on the preliminary objection was canvassed based on 4 issues, while the 5th issue was on suspected suit. I shall consider the 4 issues before going to this consider the substantive suit and the 5th issue by the defendant. My consideration of the 4 issues will not be based in the order in which the issues were formulated and argued. Added also to the 4 issues is another corollary issue, which is whether in the exhibit D19, whether in view of exhibit D19, this action was properly commenced. I shall proceed to consider the preliminary issues. Issue 1, whether commencement of the instant suit by way of originating summons does not violate provisions of Order 3, Rule 2, Sub-Rule 1, 2, and B of the National Industrial Code Civil Procedure Rules. I have considered the submissions of counsel, learned senior counsel for the parties. On this issue, I am of the view that from the question posed by the claimant in the originating summons and the affidavit evidence before the court, I have no doubt in my mind that the claimant's action did not violate any provisions of the rules of this court on commencement of action. It is also clear that the matter was brought by the claimant was not in any way contentious. It is a simple application seeking for interpretation of the provisions of the claimant constitution and conditions of service, as well as instrument of appointment of the first defendant and the issue of renewal of his appointment. As pointed out above, there is no contentious issues that will make use of originating summons inappropriate in this suit. As the law is settled, even in the event of conflict, one of the ways of resolving conflict is in affidavit is to see if there are documentary evidence in support one against the other. See the case of Tahiru versus Ahmed and others. As therefore resolve issue 1 in favor of the claimant. Issue 3, I now proceed to consider issue 3, whether of the preliminary objection, whether the claimant suit is justiciable. According to learned senior counsel for the defendant, the main cause of the claimant suit is item 8 in exhibit C14, that the renewal of the first defendant tenure as chaplain of the church for another 5 years, term. The decision was taken in the congregation meeting of 6th day of July 2025. See Exhibit D14. According to learned senior counsel, the renewal of the tenure of first defendant is within the internal affairs of the church. The church, like a political party, is a voluntary association and has liberty to take certain decisions dealing with its administration, as in the instant case. In support of this submission, reliance was placed on 3 unreported decisions of this court, which have been quoted above, which have been quoted earlier in this judgment. Let me pause here to say that the rules of this court require counsel relying on unreported cases to supply certified copies of the decision of the decision in those cases before the court can act upon those decisions. Notwithstanding the shortcoming on part of counsel, not to supply the certified copies of the decision relied in his submission. I have nevertheless took the pen in obtaining the two decisions of my learned brother, Honorable Justice O. Y. Anue, of the sitting at the oral division of this court in suit number NICS stroke 85 stroke 2016 in the case of Reverend Gideon Ehenacho versus Right Reverend Dr. Cyril Okorocha and another, and suit number NICN OW stroke 41 stroke 2014 in the case of Reverend Dr. BC Iwu versus the Board of Trustees of Assemblies of God of Nigeria, where it was held, and I quote, as quoted by the council, to bring this suit within the just jurisdiction of this court, it must be shown to have arisen as a labor or employment dispute. I am unable to find any such dispute in this case. The dispute in this suit arose from Exhibit C communicating the decision of the defendant not to renew the license granted to the claimant as a priest in the second defendant charge. It is not a labor issue, but a dispute arising from internal administration of the second defendant charge. I quite agree. Court has no jurisdiction to entertain and determine the court and to determine the claimant suit. End of court. Learned Senior Counsel asked the court to hold that the decision in the new council of the University of Calabar Chapel of Redemption, working hand in hand with the congregation of the church, which is the highest decision-making organ, to renew the appointment of the first defendant as per their minute for another term of 5 years, starting from 1st February as an ecclesiastical matter within the internal affairs of the church, a voluntary association, and therefore not justiciable or subject to judicial review. Counsel further relied on the decision in the case of Ibrahim versus Gaye and that of Chirowo versus Honda. However, all efforts to locate or obtain decision of the former president of the court prove abortive without success. I have, however, been able to lay my hand on the online decision of the U.S. Supreme Court, which was said to have been relied by the former president of the court in suit number NICN/LA/5533/2019 in the case of Adeyemo versus the Apostolic Church of Nigeria, where he was said to have applied the ministerial exception doctrine by the Supreme Court of the United States of America in the case of Kendroff versus St. Nicholas Cathedral 344-4394, decided in November on the 24th day of November 1954, where his lordship applied the doctrine of ministerial exception to come to the conclusion that the church decision not to review pastor's appointment was an ecclesiastical matter and therefore not subject to judicial review. A response, learned senior counsel for the claimant submitted that a contract of employment is not an ecclesiastical issue pertaining to religious doctrine and to license to act as a religious minister or priest, and that is not the subject matter of this suit. According to the counsel, the instant suit is on whether the first defendant contract of employment with the claimant has been renewed in accordance with the conditions of service governing the employment, to the extent, therefore, that the course of action of this suit is justiciable and within the contemplation of Section 254C1A of the Constitution as amended, which based exclusive jurisdiction on this honorable court on matters on employment and condition of service and matters incidental thereto. The legal issue presented regarding this objection borders on the legal issue presented regarding this objection borders on jurisdiction of this court to entertain this suit. By virtue of Section 2541C of the Constitution, the National Industrial Code has jurisdiction to exclusion of any other code in civil cases and matters relating to or connected to any labor employment, the conditions of service of labor employee worker, and matters incidental thereto or connected therewith under the subsection. The jurisdiction of the National Industrial Code covers all employment-related matters, including those arising from private contracts of employment, and the subsection does not demarcate between private public employment status. See the case of Skybank versus EU, where whenever a court jurisdiction over a cause of matter is challenged, it must be considered and resolved first, as any adjudication without requisite jurisdiction is an exercise in futility, no matter how well considered and how sound the decision reached therein. See Madukolo versus Intending, see First Bank of Nigeria PLC versus TSA Industries Limited, see Garba versus Mohammed, see Owoniboye Technical Services Limited versus John Hall Limited, and also Okadibo versus Emeka. It is also tried to know that whenever jurisdiction of court is challenged, the relevant consideration is the provision conferring jurisdiction on the court will come to play. Also, statute establishes the court will be examined in the light of the relief sought. The question of jurisdiction must therefore be expressly confined to the relevant provisions of the Constitution and the enabling statute. This is because with court being creator of Constitution and statute, they cannot extend their own jurisdiction, but by legislation. In this case, the jurisdiction of the court is derived from Section 254C of the Constitution and Section 7 of the National Industrial Court Act 2006. See the case of Obiewu versus CBN. See also Adela Khan versus HU Line MV. The originating summons commencing this suit, the affidavit in support, the questions for resolution, and the relief sought are inexorably the determining factor of the jurisdiction of this court to entertain this suit. In the instant case, an appraisal of the claimant's originating summons commencing this suit, the questions for determination, relief sought vis-a-vis the affidavit in support thereof will clearly establish that the subject matter of the case before this court strictly pertains to construction of the provisions of the claimant constitution and conditions of service as they relate to expiry of fixed term of 5 years contract of service of the first dependent as chaplain of the claimant and renewal of same. Therefore, the question as to expiration and renewal of the first dependent employment, being an aspect of labor and employment matter, is strictly within the exclusive preserve of the National Industrial Code as per Section 254C1 of the Constitution as amended, as well as falling under Section 7, subsection 1 of the National Industrial Code Act 2006. This means that this suit was properly brought before the court. The twin questions posed for determination in the originating summons, which have been reproduced in the earlier part of this judgment, are not strictly within the purview of the internal domestic affairs of the claimant as being claimed by the defendant. Therefore, the twin questions being for interpretation of provisions of clause or sections 36 and 37 of Exhibit C4, Constitution of the claimant, which is a binding charter on the parties in this suit, cannot by any stretch of imagination be considered to be domestic affairs of the claimant to deprive this court of jurisdiction to entertain them, as the dispute submitted for determination by the claimant as contained in the originating summons is not about who should occupy what office of the chaplain, but on when the fixed term of years of contract of service will expire and the renewal of same. The question of whether a court should interfere in the internal affairs of a religious organization like the claimant in this case is a delicate one, requiring striking a balance between the doctrine of non-interference in ecclesiastical matters and the court's duty to ensure that voluntary associations abide by their own constitution. Having regard to the reliefs and questions for resolution, it would be justified to conclude that the matter is non-justiciable, while courts generally avoid interfering in spiritual or doctrinal dispute. They possess requisite jurisdiction where there is clear breach of association's constitution to intervene once the dispute pertains to the interpretation of a registered constitution contract of service. In the case of Ididion and others versus the Incorporated Trustees of the Divine Assemblies of Christ Church of Nigeria, the Court of Appeal emphasized that matters arising from operation of Kama and administrative management of incorporated body falls within the judicial purviews of the court. In the circumstances, this should also fall within the purview of the jurisdiction of this court, since it borders on employment. In the case at hand, since the dispute involved construction of some provisions of the claimant constitution and the conditions of service regarding the tenure of first dependent and its renewal, it constitutes an employment or labor-related matter coming under Section 2541C of the Constitution of the Federal Republic of Nigeria, 1999, as amended. Therefore, this court is duly vested with the exclusive jurisdiction over the matters relating to or connected with the labor, employment, and industrial relations. This includes the interpretation of expiration of tenure and the renewal of tenure of service of the chaplain, as this is a contractual issue rather than a purely spiritual or doctrinal issue. The argument raised by the defendant that the decision of the congregation is an internal administrative affair of the claimant is rooted in the principle that voluntary associations, including churches, are masters of their own domestic houses. However, this immunity from judicial review is not absolute. The court jurisdiction is triggered the moment a voluntary association acts ultra bias its own constitution, as being alleged in this case. In this case, the court role is not to determine who is spiritually fit to be a chaplain, but to determine if the renewal of appointment process follows the due process of law of the church. The court is not being asked to decide on matter of faith, but on matter of procedural compliance with the constitution of the church. This court must uphold the sanctity of the church's constitution to protect the right of the members who are bound by it. Therefore, the objection on the ground of non-justiciability also failed. Same is hereby refused and dismissed, as the court has a duty to intervene when the internal rules of an organization are alleged to have been flagrantly disregarded and or desecrated. Let me also state that the cases cited by the counsel for the defendant to support his claim on justiciability, on his claim that the case as presented is not justiciable. That is the cases decided by the Ore divisions of this court and that of the former president are not on all fours with the case at hand. In fact, the portion of the decision of the Ore decision which the learned counsel quoted to support his case clearly supported the position taken by this court, because the issues which the claimant submitted in this case borders on employment, labor and employment, and not on internal affairs of the church or administration of the church. They are for interpretation which border on tenure and expiry on renewal of the tenure, which is an employment-based issue, which is within the exclusive preserve of this court. The cases cited are relied by the council are not relevant to the case at hand. The Ore division, the cases in the Ore divisions relate to the license for the right to grant license to clergyman, while in this case it does not relate to the license granted to the clergy. It is based purely on the contract I now move to the issue 4, which is an objection to this suit on ground of multiplicity of action. The defendants have argued this court to hold that this suit is an abuse of court process, as the defendants were served with 3 different suits dealing with the instant issue. Counsel stated first, suit number NICN stroke CS stroke 42 stroke 2025, which was filed on 11th of August 2025. And on 25th of August 2025, the suit was continued on the same date, NICN stroke CS stroke 43 stroke 2025, bearing same parties and issues which the first case was filed. Another suit, NICN stroke 45 stroke 2025. The defendant does not know which suit to respond. On 8th day of September 2025, the claimant filed another suit, HC stroke 2020 stroke 2025 at High Court of Cross River State. The said action was attached to the counter affidavit as Exhibit D9. In law, the concept of abuse of process was loosely stated by the Supreme Court in the case of Saraki versus Kotwe, where the Supreme Court carried wide JSC as seasonal of blessings memory stated that the employment of the judicial process is only regarded as an abuse when a party improperly uses the judicial process to irritation and annoyance of the opponent and the efficient and effective administration of justice, and that such will arise in instituting a multiplicity of action on the same subject matter against the same opponent on the same issue. Explaining further, the Supreme Court in that case stated that the multiplicity of action on the same matter between the same parties, even where there exists a right to bring the action, is regarded as abuse, and that the above abuse lies in the multiplicity and the manner of the exercise of the right. The lucid exposition of the concept of abuse of process in Saraki versus Kotoe does not leave room for any creative way of obviating it. The defendants insisted there is abuse since after instituting this suit, another suit filed at the State High Court. The concept of abuse of court process has been given precise definition, which has no precise use, which to say process of court has not been used bona fide or properly. See the case of Central Bank of Nigeria versus Ahmed and others. See also a J. versus Ikine. It involves an improper use of judicial process by a party in litigation. See Agwasim versus Ojichi at page 624 to 625. Furthermore, the concept is also characterized as an action initiated without a just or reasonable cause. It merely takes an undue advantage of the reason that the process is available for indulgence. It is also a situation where the law is wrongly interpreted for purposes of accommodating action in bad faith. It impugns the dignity of the court. Further still, and in the legal parlance, the phrase abuse of judicial process is generally employed where a party improperly uses to the irritation and annoyance of the opponent the efficient and effective administration of justice. An example is where a multiplicity of action on the same subject matter are instituted against the same opponent on the same suit, on the same issues. See Okoro Dudu versus Okoro Dudu. See also Okapo versus Attorney General of Anambra State. See also ACB PLC versus Uwegwi. The concept of abuse therefore lies in the multiplicity and the manner employed for the exercise of the right. See Saraki versus Koito Supra, where the abuse of court process is established, the court has power to prevent such abuse of process. The power of the court to ward off an abuse of its process is inherent for it to exercise for purposes of maintaining sanctity and dignity of the court. See Paper Sack Nigeria Limited versus Odutola. See also Ogboru and another versus Oduagan. If a suit is adjudged to be an abuse of court process, that abuse should be terminated by a dismissal and not to provide the irritant a leeway to continue recycling the irritating and annoying suit, as Inmeka Ogu JSC echoed this in Arubo versus Ayelaru. Thus, I quote, once a court is satisfied that the proceeding before it amount to an abuse of court process, it has the right, in fact, the duty to invoke the powers to punish the party which is in abuse of its process. Quite often, the power is exercisable by a dismissal of the action which constitutes the abuse. In Dingyadi versus INEC, the apex court laid down to rest the issue as to which of the suit should vacate, where two actions or similar or same of same nature and between same parties and subject matter are being prosecuted concurrently before the same court or in different courts from the above or a different court. From the above suit number court, it is the one later in time that must vacate or be dismissed by the court. From the facts as disclosed in this case, it is obvious that suit number HC 2022/2025, which was filed later in time, was the process forming the abuse of court process aimed at irritating and annoying the defendant. However, the subsequent suit having not been before this court cannot make any order respecting the said process. The council has also alluded that another suit number NICM/45/25 having been same parties and issues was served on the defendants. However, council has not exhibited that process for the court to consider whether it amounts to abuse or not. In the circumstances, the issue bordering on abuse of court processes has not been established. Sorry, counsel. Let me. Has not been established. Therefore, the said issue is resolved, is hereby dismissed. On issue 2, whether which will conclude the 4 issues argued in objecting to the present suit is whether the minority action of a certain persons who are aggrieved by the decision of the chaplain of the church congregation in the name incorporated trustees of the church is properly constituted in bracket grounds 3. Let me say that in the context of an incorporated body, such as the incorporated trustees of the claimant, the entity possesses a distinct legal personality separate from its members. This principle implies that entity can sue and be sued in its corporate name. However, the power to institute legal proceeding is not absolute and must be exercised by the authorized organs of the entity, typically the board of trustees, acting through a validly passed resolution. The foundation principle obtained, referred to as the rule imposed by Sobotu, dictates that for a wrong done to a corporate body, the proper claimant or party to sue is the corporate body itself. From the evidence before the court, this suit was brought based on Exhibit C3 resolution passed by the claimant's board of trustees. Therefore, this suit was not filed by any minority member of the claimant. This action is said to have been filed by some of the registered trustees of the claimant, whose names are listed in the claimant's certificate of incorporation marked attached to the affidavit in support of the originating summons and marked as executed. The law treats registered trustees as a single corporate entity. According to Section 830, subsection 1C of the Companies and Allied Matters Act 2022, from the date of registration, the trustee become a body corporate and have the power to sue and be sued in their corporate name. That exercise of this power is governed by Section 837 of the CAMA, which stipulates that power vested in the trustee shall be exercised subject to the direction of the association or the council or governing body. In Tombat Fitting and Pictures Limited versus Incorporated Trustees of Bilmo Estate Nigeria United Residents and Stakeholders Association and others, the court clarifies that the focus must be on whether the governing body authorized the action. If the council of the church pass a resolution authorizing the filing of the suit, the action is validly instituted in the corporate name of the registered trustees. The individual dissent of some trustees does not vitiate the action, as the trustees act as a collective corporate personality directed by the governing council. The law is clear, even where some members of the board of trustees, like in the case at hand, as argued by the defendants, the two members of the board of trustees were not aware or did not participate or authorize in the resolution that cannot vitiate the said suit. A corollary issue to the issue 2 is whether, in view of Exhibit D 19, this action was properly commenced. For an action to be commenced in the name of trustees and organized on organization registered under Companies and Allied Matters Act, like the claimant in this suit, must depend on explicit authorization by the trustees, without which an action will be invalid. Therefore, the ability to institute legal action in the name of registered organization such a legal action must be authorized by the trustees. Generally, for an action to be validly commenced in the name of trustees, there must be proper authorization. This aligns with the principle governing deviation of action and the derivation of action and the representative of corporate bodies, both of which require adherence to statutory procedure or proper authorization, as the case may be. As in this case, it is the authorization that matters. It is also well settled law for there to be a valid and competent legal action before a court of law, there must be at least a competent claimant with the requisite legal capacity or standing to sue, and a competent defendant also with the necessary legal capacity or standing in the eyes of the law to be sued in the action. In the absence of competent claimant or competent defendant, there cannot be a competent legal action or suit before the court of law over which its jurisdiction could be properly invoked. In Ikimi versus Ikimi, the court has this to say, I quote, "A competence of an action is dependent on whether it was brought by the due process of law before an appropriate court or by a person who is entitled to bring such an action. A suit is competent to be adjudicated upon by a court of law where there is an existence competent parties, that is to say, a plaintiff and a defendant capable of being sued in a court of law, and a cause of action. See the case of Ayolinde versus Oni. See also Onue Kwisi and others versus registered trustees of Christ Methodist Zion's Church. See also Ibadan Electricity Distribution Company PLC versus Landmark University. See also Osua versus GOC Nigeria Limited and others. End of quote, per OTC JCA. In the instant case, the registered trustees of the Unical Chapel of Redemption are the legally recognized body to authorize the institution of an action on behalf of the church as its legal representatives. However, their authority to embark on significant action like initiating legal litigation must be grounded in explicit and valid resolution passed by the Board of Trustees. An action commenced without such authorization will is without any necessary legal standing or authority. The authorization of institution of an action is crucial and is crucial for the validity of the action. In the further counter affidavit, it was averred that the investigation into the issue and the disparities relating to the update of registration of the incorporated trustees of the Unical Chapels of Redemption, the Corporate Affairs Commission had confirmed that the certificate of incorporation paraded by the claimant was not obtained properly, as same was obtained without adherence to the requisite statutory procedure. See Exhibit D19, letter from Corporate Affairs Commission, nullifying the effect of the change of the trustees of Unical Chapel of Redemption and returning same back to the status quo ante bellum. The defendant, based on Exhibit D19, argues that Exhibit D3 cannot grant authority to sue since the signatories of the resolution in Exhibit are not the trustees of the claimant. The suit was brought in bad faith, having been brought without the authority of the surviving trustees, namely Professor Emmanuel Efiong Edet and Mrs. Mbechi Ovone Uka. The claimant, in its response to the further counter affidavit, stated that the issue of change of trustees is pending before the Federal High Court. Paragraphs 10 to 20 of the defendant's counter affidavit are revealing in that the defendant denied carrying out any change of trustees as per Exhibit C2, as according to them, the process of change has not been done, as successive executive of the council leadership refused to register the changes with Corporate Affairs Commission. The deponent of the counter affidavit, who is a founding member of the Board of Trustees, denied issuance of Exhibit C3 by the trustees, as she was not invited for any meeting for the meeting that produced Exhibit C3. The combined effect of paragraphs 10 to 20 of the counter affidavit, as well as further counter affidavit and the attached exhibits therein, clearly established that there were irregularities in the whole process that produced Exhibit C2 and C3, which are the basis for institution of this suit. The foundations having been knocked off the bottom, I have no choice than to come to the conclusion that there was no proper authority for institution of the present suit, as it is properly constituted, as the true Board of Trustees, as the true members of the Board of Trustees to authorize the suit did not do so. At any time, they did not pass any resolution bringing this suit to the court. In the circumstances and in view of Exhibit D19, there is no proper claimant before the court. In the absence of proper claimant, the suit has no legs to stand. It must be struck out, and I hereby strike out this suit for lack of proper authorization. The resolution of issue 2 to the effect that there is no proper resolution by the trustees to authorize institution of this case has ended the lifespan of this suit, as it has been struck out due to absence of authorization of the institution of this case due to absence of proper claimant before the court. However, this court being the court of first instance, I have a duty to proceed to determine the twin questions submitted for resolution by the claimant in the originating summons. In case there is an appeal to the Court of Appeal, The Court of Appeal will have the benefit of the views of this court on the issue. The claimant in this suit approached this court via originating summons seeking resolution of twin issues and in anticipation favorable resolution of the two issues posed for determination sought by 5 reliefs. I have herein before reproduced the questions and the reliefs being sought by the claimant. The first question is on first dependent employment and the tenure as the chaplain of the claimant will terminate on 31st day of January 2026, having regard to the combined effect of paragraph 2 of the first dependent letter of appointment exhibit C5 dated 8th of November 2020 and the provisions of article 7B and 39H of the Constitution and the Constitution of conditions of service of the claimant, as well as sections 36 and 37 of the Constitution of the claimant, exhibit C4 and C6 respectively. At page 3 of the written address of the defendants, it was stated that it was not disputed that the terminal date of the first defendant first term of office is 31st day of January 2026. In view of the agreement of counsel for the defendant to the position of the claimant on tenure of office of the first defendant, the question 1 of the originating summons is hereby resolved in favor of the claimant. That is to say that the tenure of the first defendant, in this case, expires on January 31st, 2026. Now, what remains to be considered, which the parties are disputing, is the second question for resolution. That is section 36 and 37 of Exhibit C4, which are some of the provisions to be interpreted, which are the provisions to be interpreted. Section 36 provide as follows: a new chaplain shall hold office for a period of 5 years, after which he shall be eligible for renewal for a further term of appointment subject to approval of council and congregation. An incumbent chaplain desiring a renewal of appointment shall within 12 months before the expiration of his tenure submit to the chairman of the council an application upon which the council shall act or pronounce within 3 months. Section 7, Article 7 on procedure for appointment and declaration of vacancies provide vacancies to be filled in Unical Chapel of Redemption shall normally be advertised. B. The position of the clergy shall be subject to provisions of union, constitution, and decision of the council. The Unical Council. Article 39, Section 39H, which is on cessation, termination of employment, provide as follows: the appointment of an employee may cease to be terminated may cease or be terminated in the following ways. H, on the expiration of tenure of engagement of the chaplain, in bracket chaplain. The position of the claimant is that the first defendant was appointed as per Exhibit C5, dated 8th of November 2020, to serve for a term of 5 years on salary of 3,091,505 naira 4 kobo per annum on UNORSS A5 Step 1. Allowances and other entitlements are as provided in the conditions of service, Exhibit C6. For the appointment to be valid, it must be accepted within 7 days. By the Exhibit C7, the first defendant accepted the said offer of appointment as per Exhibit C5. The acceptance of Exhibit C5 by the Exhibit 7 established the employment relationship between the claimant and the employment relationship between the first claimant and the first defendant was consummated. It is to be noted that the first defendant applied for the position of chaplain to the counsel of the claimant. It was after an interview that the claimant was offered employment, which he duly accepted to serve for 5 years. The bone of contention between the parties is on the renewal of first defendant appointment for another fixed term of 5 years, as per sections 36 and 37 of Exhibit 4 Constitution of the claimant. For the defendant, the congregation has the final say on issue of renewal, as according to them, the pronouncement of counsel or renewal has to be subjected to congregation. And that was what the defendant have done. And the congregation at a meeting held on 6th of July 2005 approved the renewal of first defendant appointment for another term of 5 years to begin in January, on 1st January 2026, where a court of law is called upon to interpret provisions of documents like Exhibit C4, C5, C6, and C7. The primary objective is to ascertain the true intention of the makers of the document or the legislature that authored the instrument. This process is governed by established canons of interpretation designed to ensure certainty, fairness, and preservation of the parties' original agreement. The most fundamental principle is that words in a document or statute must be given their ordinary plain and grammatical meaning, as established in Olutoye versus Cole and another. The court must construe words in the context in which they appear and must not interpret extraneous words into the text unless the document is otherwise incapable of meaningful interpretation. The court's role is not to rewrite the contract or make a new one for the parties, but to give effect to what is contained within the four corners of the document or instrument to be construed. This position is supported by the decision in the case of Melronian General Services Limited versus EFCC, where the Supreme Court emphasized that the literal rule requires according words their ordinary grammatical meaning without embellishment. The court, faced with the request for construction of provisions of document or statute, is expected to employ holistic, harmonious construction. This means in construing the instrument or provisions to be interpreted, court must interpret a single clause, must not interpret a single clause or sentence in isolation. Instead, it is granted as unbridled license to read a document holistically to achieve a harmonious result. In the case of Abre and another versus Mimra and others, the court held that the object of interpretation is to find the correct meaning of the word in relation to the entire agreement. If another section is unclear, other sections or the document as a whole must be read together to ascertain the meaning. This ensures that no part of the document is rendered redundant or interpreted in a way that contradicts overall purpose of the instrument. Also, where multiple documents form part of a single transaction, they must be read together rather than in isolation. According to Ali, the case of Ali and another versus Lakeside News Limited, a restrictive or narrow interpretation that fails to account for the total package of the transaction cannot meet the justice of a case. This contextual approach allows the court to fully appreciate the legal import and impact of parties dealing. In order to resolve question 2, I have holistically taken a hard look at the entire processes filed by the parties, the exhibit attached to the affidavits of the parties, the written and oral submissions of learned senior counsel for the parties. As noted earlier, the area of dispute has been narrowed down to appointment as per Exhibit C8 as provided by Clause 36 of Exhibit C4. The congregation has as noted earlier, the area of dispute between the parties has been narrowed down to whether in processing the application of the first dependent for renewal of his appointment as per Exhibit CA, as provided by Section 36 of Exhibit C4. The congregation has the final say, and if and it is this and it is the decision of the congregation. That is whether the congregation has the final say and its decision is final on the matter. I have reproduced the provisions of sections 36 and 36 above. The above provisions are very clear and unambiguous, and it says what it says. The word used in the provision must be given their literal ordinary meaning. This is because the principle of interpretation as well as known This is because the principle of interpretations are well known. Suffice it to say that for our present purpose, that it is settled that where the wording of the provision in a document to be construction are found to be clear and unambiguous, it is neither necessary nor permissible to look further. See the case of NABA versus NABA. What brought about the dispute in this case is the contentions of the validity of the renewal of tenure of first dependent by the congregation. It is interesting to note that the dependents have, by the evidence adduced through their affidavit before the court and the exhibit attached therein, have admitted the renewal of the tenure of the first dependent. It is clear to me from Section 36 of Exhibit C4 that for the approval of renewal of tenure of first dependent to be validly made, such approval must be made by the council and the congregation. The renewal will depend strictly on the interpretation of the church constitution, where a constitution provides a specific procedure for renewal, as in this case, requiring approval by both the council and the congregation. Those requirements are condition precedent to the validity of such approval. If the council decline renewal, as well as a reconciliation committee as per Exhibit C12 and D16, then the subsequent approval by the congregation alone is insufficient to satisfy the dual requirement of Section 36 of Exhibit C4. In Java Local Government Council versus Chigozie and others, the court highlighted the importance of fulfilling stipulation, that is, conditions before a right of a status such as a new tenure can be conferred. Since the council's approval is a mandatory constitutional requirement, the congregation cannot unilaterally override the council's decision unless the constitution specifically provides for such a veto or alternative path. I have perused the constitution, the entire constitution. There is no such power conferred on the congregation to veto whatever the council has refused. In any event, since the constitution of the claimant stipulates a dual approval process, council and congregation, the failure to obtain council's approval is a procedural irregularity that the court can and should adjudicate upon. In the case at hand, the approval of renewal by congregation is in disregard of the refusal of the council must not be sanctioned by this court. Since such approval Since such approval of the renewal by the congregation cannot be valid in the eyes of the law, cannot be valid in the eyes of the law. In the circumstances, this court must uphold the sanctity of the church constitution to protect it against any abuse. Therefore, for any renewal to be effective, it must be approved by both the council and also the congregation. The position I have taken on the construction of the provisions of Section 36 of Exhibit C4 is supported by the Supreme Court decision, where it was held that the words "and" in a provisions of statute or document connote conjunctive. See the case of Luna versus Commissioner of Police, Rivers State. The words "and" is conjunction connecting or the phrase expressing the idea that the latter is to be added or to taken along with the first added to. It expresses a general relationship or connection, a participation or accompaniment in sequence, having no inherent meaning, standing alone, but deriving from what comes before and after. In its conjunctive sense, the word is used to conjoin words, clauses, or sentences expressing the relation of addition or connection, and signifying that something is to be followed in addition to that which proceeds. And its use implies that the connected elements must be grammatically coordinate as where the elements proceeding and succeeding the use of the word refer to the same subject matter. In the instant case, the use of the word "and" in the rule under construction means that the application for enforcement must be supported by both statement listing the reliefs and ground and affidavit verifying the facts relied on. See page 290 of that decision. Applying the above dictum of the Supreme Court to this case, the word "and" used in section 36 of Exhibit C4 means that the approval needed to give impetus to the renewal of tenure of first defendant must be given by both the council and the congregation. Where one organ approves, the other withheld approval, the renewal cannot be effective. And what that means is that there was no approval. Once the council refused, there will be no renewal. If the renewal by the congregation cannot suffice to validate the renewal. From all I have been saying above, the claimant succeed in its request as per the twin questions for resolution are concerned. They are resolved in favor of the claimant. However, having found this suit not to have been authorized by the true trustees, it is hereby struck out for lack of jurisdiction to entertain same due to lack of absence of proper authorization. Before I put full stop on this judgment, I must state that it is as I am I'm astounded and disappointed that nowadays religious organizations are falling into traps set by devils to mislead them to be fighting over position. It is more disheartening taking into consideration the extent to which those charged with the affairs of the religious organization are involved in hanky-panky deals to distort record simply for the urge of installing their stooges to be strategically placed to govern the affairs of the church. I hope God will touch the mind of religious organizations in this country to lead in the right way without rancor and to properly adhere strictly to the constitution establishing their churches. I say no more on this. I make no order as to cost parties to bear their respective cost. Judgment is hereby entered accordingly.
As the court pleases.
Court pleases.
We thank your lordship.
Just delivered.
We thank my lord.
You are welcome. Registrar, any other matter for today? For virtual?
No, my lord, that's all.
Okay, thank you,
That's
counsel,
all for today, my lord.
Counsel, for being us. We have come to the end of today's proceeding. The administrator, you can discontinue with the sitting.
Thank you very much.
Thank you, my lord. Well done.
Thank you. Okay. You people have read the judge.
I can't hear what they're saying.
No.
What idea is Bayo?
This is a video.
With the video.
This is a video. Emoção. So
Does it exploit now?
Okay, are you sharing?
We should leave it. Sunday morning or how?
Because this is the video. It's from YouTube. I don't share this. But the call is still clear.
Nah, Sunday.
Mm.
How are you?